The other question we get from potential clients and existing clients who are wondering, why do I need to bother with this, is what will happen if I die without having any planning in place. So the planning documents that come into play if you die in Michigan are going to be beneficiary designations. So a lot of people will have those on accounts. But sometimes things happen to the people who you've designated, and it will really depend on the rules for the different financial institution, who's the backup. So if you and your spouse both die and you don't name any contingent beneficiaries, it could end up going into probate, it could go to your children. It all depends on how those things are set up. And as far as how those decisions are made, it's just, there's a statute that says your spouse gets some of the money, your kids get some of the money. If you've been married twice, there's an even more complicated formula. If you don't have a spouse or children, then it's your parents and your siblings, and it really never ends up being what somebody would choose on their own. And again, you've got to go through the court process. So you could have an intestate estate, and the formulas are different for that than if you've got a will, and there's different statutory rights and all of those things, which can all be avoided, and you can make a plan to do exactly what you want to do and not what the legislature wants for you, which is kind of sawing the baby in half kind of a situation. You get to pick who gets what, when they get it, how they get it, who's going to be in control of it, and you can use a revocable trust to do that. And we can talk more about that in your meeting as to whether a trust works well for what you're trying to do, or if we can just do beneficiary designations in a simple will. But those documents will say what you want to have happen and put people in charge to do it efficiently and in a manner that you would want it to get done.